Hello, it's Case Wednesday. On Case Wednesdays, what we do is that we take a case, discuss the case, and talk about the relevant facts that you should know as an individual from the case. So today, our first case on Case Wednesday is the case titled Peter Ajay versus Margaret Ajay. So here are the facts of the case. So in that case, it was a divorce, divorce of a customary law marriage. So after the divorce, the petitioner, that is Margaret Ajay, went to court for the sharing of the properties and custody of the children. One of the property, the main property that was in contention, was a 4-bedroom flat in Cantonment. And so at the High Court, the custody of their children was given to the petitioner, with the respondent having limited access to them. They gave her an amount of money as alimony. Now let's come back to the main issue, that is the four flat apartment at Cantonment. Initially, at the High Court, the judge gave her one flat out of the 4 flats. The respondent, who is Peter Ajay, then petitioned or appealed to the Court of Appeal. And at the Court of Appeal, his whole argument was that that property, which was a 4-bedroom flat, was acquired from a loan he got from the bank, and that he had not even paid all the loan in full. So he took a loan to buy the land and to also build the property, that is the 4-flat house in Cantonment. So the Court of Appeal reversed the decision of the High Court, stating that the petitioner, who is the woman, Margaret Ajay, was not entitled to any of the property. Then the woman, being aggrieved, she wasn't okay, then appealed to the Supreme Court. So this is what the Supreme Court said concerning the 4-flat apartment at Cantonment. The Supreme Court said that if you take a loan to acquire a land and subsequently to put up a building on that property, and you have not fully paid for the loan, then that property, even though it was within the time of subsisting marriage, does not become a matrimonial property. And so the Supreme Court upheld the decision of the Court of Appeal, stating that since Peter Ajay has not fully paid for the loan, the property does not become matrimonial property, and so the woman was not entitled to any part of it. So our lesson I want us to learn from today's case is that if you acquire a property within the time of marriage, and you acquire the property by taking a loan, and the person has not fully paid the loan, and there's dissolution of the marriage, that property does not become matrimonial property when sharing the property. So let me give an example. So our usual example, Anas and Kwamina. So let's say Anas and Kwamina have been married for some time, let's say 10 years, and within that time, Kwamina took a loan to put up a 5-bedroom house at Ahonjo. And within that time, before the dissolution of the marriage, Kwamina has not fully paid for the loan. Then that property that he is putting up, even though it was within the time of the marriage, does not become matrimonial property. Please, let's learn from this note, and whenever there's dissolution of marriage, we know the kind of properties that will amount to matrimonial property. Thank you, and bye-bye.